Good morning, all. Just wanted to jump on here and go over a recent officer-involved shooting that occurred in Chicago that's been getting a lot of attention in the media as of late, as well as mixed opinions on the outcome from the general public. I want to come at this from the legal justification piece versus reviewing anything involving tactics or individual police department policies. The information is geared towards those with no law enforcement background or legal background, and to put some of the legal terminology in plain language so you guys can form your own rational and informed opinion, not just regurgitating what you see online. This overview will be mostly audio, so you won't be missing anything if you're listening to this driving to work or at the gym. If I can figure out how to splice the original body-worn camera clip on here at the end, I will. Otherwise, I'll post a link in the description. As a disclaimer, I am not an attorney, and my views do not necessarily reflect those of any specific agency or department. For reference, I've worked in law enforcement for a few years, and I'll keep it at that for reasons I'm sure you all can understand. In summary, the incident took place on April 15th, 2023, around 10 a.m. in Chicago's West Garfield Park area on the city's west side, which is known to be a very high crime area. Shootings, murders, violent crimes, etc. It involved two Chicago police officers and a 24-year-old male subject. Officers spotted the involved male standing outside. They exited their patrol vehicle, and the subject immediately flees upon seeing the officers. The officers then pursue him on foot and through an alley, and then eventually locate the subject in a different alley, which is at a dead end. He draws a pistol from his waistband, puts two hands on the gun, and points it at the direction of the officers. The primary officer subsequently shoots the subject, who is immediately incapacitated and later pronounced deceased. This breakdown is going to cover a couple different topics. First is going to be the current assignment of the officers involved, investigative stops/Terry stops, reasonable articulable suspicion, Supreme Court case Illinois v. Wardlow from 2000, and then Illinois and federal use of force information. Starting off with the officers' assignments, they were part of a TAC team, also known as a street crimes unit. I'm sure my Chicago police officer guys in here can chime in and let me know what the specific nomenclature for the unit is these days. It used to be a community policing unit. It's changed like 17 times, but in general it is a street crimes/TAC type team. Regardless, these officers wear plain clothes, typically jeans, t-shirt, or a hoodie, and then they wear an outer vest carrier, which has police markings on it and usually pistol-rated body armor on the inside. They are clearly recognizable as police officers, especially in this area. They are a proactive unit, meaning that they're not specifically tied to the radio. They're not getting dispatched to disputes or petty thefts. Their mission is very simple: find bad guys and arrest same. Right? That can be anything from finding guns, drugs, suppressing gang violence, and crime suppression in general. So jumping over to investigative stops. In order for police to detain someone, or simply put, restrict someone's freedom of movement, requires reasonable articulable suspicion, usually shortened to reasonable suspicion or simply RS. It can be defined as facts and circumstances that would lead a reasonable officer to believe that the subject is or is about to be involved in criminal activity, or circumstances that would lead a reasonable officer to believe criminal activity is afoot. The standard was better laid out in the landmark U.S. Supreme Court case Terry v. Ohio, 1968. You may have heard of Terry Pat or Terry Frisk, all of which are stemmed from this case. So take a look at that case brief if you want to know more on that. So in order for police to stop and detain someone, right, restrict their freedom of movement, officers need reasonable suspicion of criminal activity. That's the level of certainty that's higher than a mere suspicion or a hunch, but lower than the Illinois' arrest standard, which is probable cause. For reference, probable cause is facts and circumstances within the officer's knowledge that are sufficient to warrant a belief by a person of reasonable caution that an offense has been committed and that the person to be arrested has committed it. Simply put, the probability that the crime occurred. So, the important question for this case is, how can these officers stop a person simply for running away? What crime is he suspected of committing or about to be committing? Another Supreme Court case that covers almost this exact situation is called Illinois v. Wardlow. It's Wardlow. That's in 2000 Supreme Court case. Covered the justification of an investigative stop and subsequent pat-down of a subject who spotted a large police presence and then decided to flee in a high crime area, which is a high drug trafficking area, and the officers eventually stopped him, frisked him, and found contraband. In that case, they noted that unprovoked flight, nervousness, and evasive behavior were cited as elements to justify the stop. The Chief Justice in this case noted that flight alone is the consummate act of evasion. So adding those factors together gave the officers in that case, as well as this case that we're talking about today, reasonable suspicion to stop the subject for further investigation. After the officers caught up to the man, in our case, we go into the final two talking points covering the deadly force, use of deadly force itself upon the man who pulled a gun on police. This use of force is mainly going to be judged under two categories. The first will be Graham v. Connor. It's a 1989 U.S. Supreme Court case, which is the most referenced case regarding police use of force today, as well as Illinois compiled statutes, aka ILCS, related to deadly force used by police, which can be found under 720 ILCS 5/7-5, titled Police Officers or Peace Officers' Use of Force in Making Arrest, which has been updated somewhat recently with the Safety Act, restricting law enforcement further. All right, so in short, Graham v. Connor was a case that established the objective reasonableness standard, which reviews police use of force. It also outlines the guidance that police cannot be judged in 2020 hindsight from the use of force standard, but from the standpoint of a reasonable officer knowing the same facts and circumstances of the incident at the time force was used, aka putting yourself in the officer's shoes and not watching it from a drone 10,000 feet above. The Illinois specific deadly force requirements fall under 720 ILCS 5/7-5, which state he is justified in using force likely to cause death or great bodily harm only when he reasonably believes, based on the totality of the circumstances, that such force is necessary to prevent death or great bodily harm to himself or such other person. Simply put, taking into account the information I've provided, plus the totality of the circumstances on scene, this incident can and should be considered a justified use of force. I hope this information helped you. If you have any questions or comments, let me know. I'll do my best to answer them. If you feel like these types of incidents shouldn't be allowed to happen, educate yourself in the current laws, right? Case law, the use of force process, and then contact your local House and state representatives and make your voice heard, right? Educated responses are much better than emotional-based arguments. All right, take care.
Eleven, 6, 2, 10-1, shots fired, shots fired!